Welcome to the Elder and Special Needs Practicum webcast series presented by the National Elder Law Foundation and Western New England University School of Law. My name is Faye Blix and I'm a co-chair of this series. These webcasts have been designed as a refresher and a continuing education series for those who have achieved the designation of Certified Elder Law Attorney by the National Elder Law Foundation, the only organization permitted to do so by the American Bar Association. Persons who intend to seek this certification should understand that the certification exam is prepared independently from these webcasts. The exam may offer other and more current topics. This series of webcasts should be considered only a survey of the various topics of elder and special needs law, and no substitute for a thorough study of the 12 areas of elder and special needs law that are covered on the certification exam. This webcast focus will be on the Defense of Marriage Act and is presented by Jennifer VanderVeen. Ms. VanderVeen is a certified elder law attorney with Tuesley Hall Canopa in South Bend, Indiana. And she is a member of both the Indiana and Michigan state bars. She is a member of the board of directors of the National Academy of Elder Law Attorneys and is a past chairperson of the Indiana Elder Law section. She has significant experience in the area of business planning, as well as counseling clients in elder law, estate planning, estate taxation, gifting, special needs, guardianships, veterans, Medicaid benefits, and probate. Jennifer VanderVeen.
When Faye and Ian first contacted me about speaking about the Defense of Marriage Act, I called Ian back and I said, "The Defense of Marriage Act is dead, thank you, good night." And he quickly clarified that no, that wasn't really what they wanted me to speak on. So what I'm here to actually talk about is planning in the post-Windsor era. As we all know, the Defense of Marriage Act was virtually eliminated by the Windsor decision, and as a result, marriage is governed by the states. So until we reach the point in this country where every state has the same level of marriage equality, we're essentially living in limbo. Because what we will have is 50 separate sections that you have to plan for. In today's age, people are not born, live, and die in the same state. It just doesn't happen like it used to. We've got a much more mobile society, and people are moving between states. So as people move, the marriage laws change. And it's not a political statement to say, until we have full marriage equality in all 50 states, planning becomes very complicated. We recently had a NELA member who resigned his membership because he felt NELA had focused too much on same-sex marriage planning. We've had 3 webinars in the last year. And my response to him was, that's fine. If you oppose same-sex marriage, that's understandable. That's your position. However, you're doing a disservice to your clients if you don't know how to plan for it. Because even if you don't have clients who are same-sex couples, your clients may have children who are same-sex couples. And as I'll discuss a little later on, that can affect how you plan for mom and dad. The key question in any same-sex planning is, where are you planning? Which states allow what? As of right now, like I said, we've got virtually 50 different plans. You have to ask your clients, where do they live? Where do they work? Where were they married? Because each of those answers will affect how you plan for that client. Currently, there are 17 states that explicitly permit same-sex marriage, giving same-sex couples completely equal rights to heterosexual couples. We have 3 states that allow domestic partnerships or civil unions. Wisconsin currently only allows limited domestic partnerships. Oregon will recognize a marriage if it's performed elsewhere. Now, this is, as we stand here today, April 4th, 2014. I fully expect that by the time this even goes live on the NELF website, this will have changed. The website I've listed there, freedomtomarry.org, is a good reference to keep track of what states are allowing what and when. Currently, as I give this presentation, I'm here in Massachusetts. And Massachusetts was one of the leaders around the nation in permitting same-sex marriages and giving equal rights to same-sex couples. As Faye mentioned, I practice in Indiana and Michigan. Michigan is currently in the process of being forced by the federal courts to recognize same-sex marriages. It is before the Court of Appeals. Hopefully we'll have a decision before the end of the year. There are actually 300 couples that were married in one day in the state of Michigan before the decision was appealed and a stay was issued. I also practice in Indiana, which, despite all of the political tides to the contrary, is actually still trying to pass an anti-same-sex marriage amendment to our Constitution. So we still can't buy liquor on Sundays either, so we're not exactly a progressive state. For purposes of federal benefits, this was the primary crux of the Windsor decision. The federal government now must recognize same-sex marriages performed in states where it was legal at the time of the marriage. The current general federal policy, and this is from the Attorney General, stating that the current federal policy is to recognize marriages based on the state of celebration, not the state of residence. Now, this is policy. These are words out of Eric Holder's mouth. They have almost no precedential value because, as you will see, each agency is making its own rules as to which marriages to recognize. Let's start with the one that most of our elderly clients are going to be concerned with: Medicare and Social Security. You would think, being 2 very similar agencies, they would have similar rules, but they don't. For Social Security purposes, the domicile at the time of application controls. Now, on the Social Security website, they have pages and pages of questions and answers regarding the recognition of same-sex marriages. And as you go through, it will always use the example that the couple was married in the state of Massachusetts, and then subsequently one or both of the individuals moves to Texas. So they're apparently picking on Texas as the last holdout because they don't want to change these frequently. So according to Social Security, if you are married in Massachusetts, you apply for benefits in Massachusetts, and then subsequently move to Texas, Social Security will recognize the marriage. However, if you are married in Massachusetts and then move to Texas and apply for benefits, currently Social Security is putting those applications into a holding pattern. It gets even more confusing if you are married in Massachusetts and one member of the couple moves to Texas. At that point, you have to look at who is the number holder according to Social Security. That is, who is the primary Social Security recipient. If a spouse is going to be drawing off of another spouse's record, the spouse whose record you are drawing off of is considered the number holder. If the number holder continues to reside in Massachusetts, where the same-sex marriage is legal, Social Security will apparently award spousal benefits to the spouse in Texas. But if the situation is reversed and the number holder moves to Texas, Social Security will not pay the benefits to the spouse living in Massachusetts. Now, again, this is all policy at this point. Keep in mind there has been no statutory changes since the Windsor decision. So this is all in flux. And the Social Security website is very upfront about this, that the situation is continuing to evolve and change. To further complicate things, let's talk about children of a same-sex couple who could potentially draw benefits based on a same-sex marriage. In that case, Social Security looks to whether the number holder is the biological parent. And if you are in a state that does not recognize same-sex marriage, unless the number holder is a biological parent, Social Security benefits will not be awarded to the child. If you are living in a state that recognizes same-sex marriage, it doesn't matter if the number holder is the biological or adoptive parent, but there must be a legal adoption in place for the child to draw Social Security benefits based on that person's record. Medicare, if you want to get Medicare benefits based on your spouse's work record, Medicare uses the state of celebration and they don't care where you're living. So if you were legally married in Michigan on that one day back in March, even though Michigan no longer recognizes same-sex marriage, Medicare will allow you to get Medicare benefits based on your spouse's work record. Veterans benefits is another area where you would think we would have one rule that fits all. But we don't. There are two agencies that control veterans benefits. There's the Veterans Administration, which controls benefits primarily for retirees and veterans. And there's the Department of Defense, which is active military and military retirees receiving military pension benefits and TRICARE through the Department of Defense. The VA, initially when the Windsor decision came down, said that's great for all the other federal agencies, but if you look at the VA implementing regulations for their spousal benefits, it is defined in the statute that a spouse is a member of the opposite sex. So we don't have to follow the Windsor decision. There was a case in California about a month later that said, oh, yes, you do. And the government decided not to appeal that. So the VA has adopted the state of domicile as the controlling law. So if you are married in Massachusetts and you move to Texas and you live in Texas at the time you apply for benefits, you will not be recognized as a same-sex couple by the Veterans Administration. Primarily what this is going to affect is your disability compensation awards to surviving spouses and pension benefits such as the aid and attendance pension that a lot of our clients are applying for to afford assisted living. If you are living in a state that does not recognize your marriage, you cannot get these benefits through the Veterans Administration. The Department of Defense, which you would expect to be the staunchest opponent of same-sex marriage in the federal government, is actually one of the most liberal. They look at the state of celebration. Not only that, they have allowed for leave for any service member who wishes to travel to a state of celebration in order to marry his or her partner. So they are encouraging couples to get married, to travel to those states that will allow them to get married. Because for military spouses, it's more than just qualifying for your spouse's retiree pension or getting your TRICARE benefits. It actually can be access to your home if you live on base. Because if you are not a spouse, getting the ID card that gets you onto base can be very difficult. Medicaid, as we all know, is a federal program run by the states. So now we're back to 50 different rules. The state of application is the state that's going to control. Plain and simple. And, in an area like where I practice, South Bend, Indiana is dead on the border between Indiana and Michigan. And if I have clients in South Bend who are same-sex couples, I'm betting that in a few months I'm going to be telling them to put their spouse in the nursing home across the border where we can get benefits and we can take advantage of the spousal impoverishment rules that we can't take advantage of in Indiana. CMS has made the rule that states can elect whether or not to recognize same-sex marriages performed in other states. They're leaving that up to the states to handle. But when you're talking about Medicaid planning, marriage works both ways. It can be a good thing to take advantage of the spousal impoverishment rules. However, if you're looking at a couple where the wealth is disparate and is not held jointly, it may be a curse to the wealthy spouse to get married and then have their assets subject to spend down by the less well-off spouse. And I'll talk about that towards the end of the presentation when I talk about the decision on whether or not to marry. The biggest trap you're going to run into when planning for Medicaid for a same-sex couple in a state that does not recognize same-sex marriages is the joint account. I had a couple that I was planning for who had been together since the mid-60s. Everything was held jointly. And I went to our state's policy division and I said, I need a ruling. I need to know if I divide out these joint assets, how it's going to be treated. And in the state of Indiana, I was told that unless I prove contribution, any division of the joint assets would be considered a penalizable transfer. Well, let's try proving contribution back to 1967. Most banks, you have a hard enough time getting records 5 years back. So in that case, what I ended up doing, and what I have done a couple of times since then with joint accounts, is I went to our probate court. And I simply put the individual in the nursing home under guardianship. And I went to the probate judge and I said, Judge, this individual is now under guardianship. Here are all the joint accounts. I need you to tell me which of those accounts are subject to the guardianship and divide the assets. And at least in Indiana and Michigan, our state Medicaid agencies have recognized those court orders, and I have avoided penalizable transfers in splitting out joint assets. It depends on the probate court judge as to how they divide out those assets. I will admit that some judges are very willing to allocate more assets to the individual at home than to the individual in the nursing home. And some judges say it is a 50-50 split, and there's no further discussion on the topic. So you need to know your judge and know your state. Like I said, luckily here in Massachusetts, you have full recognition, so you can take advantage of the spousal impoverishment rules. The other big benefit to the Windsor decision for most people was the tax benefits and dealing with our friends at the IRS. Because now, for the IRS, the state of celebration controls, which means that if you were legally married here in Massachusetts and you moved to Texas, you can file a married filing jointly federal tax return. When the Windsor decision first came down, I was talking to one of my best friends, and we were discussing whether he and his partner would be getting married as a result of the Windsor decision. And he said no, they would hold off until their states of residence recognized the marriage. So one of them lives in Kentucky and one of them lives in Virginia. And Kentucky recently was forced by the federal courts to recognize marriages performed elsewhere. So I called my friend and I said, so what are we doing? And he said, no. Because if they were to be legally married, they would have to file as many as 5 separate income tax returns every year. Because for the IRS, they can file married filing jointly. But in Virginia, they can't. So what they would have to do is then prepare 2 separate federal income tax forms as individuals so that they can get the adjusted gross income to report on their state returns because the state doesn't recognize the marriage. And then they file jointly in Kentucky because Kentucky does recognize. So it can become a paperwork nightmare. But in most cases, the tax benefits of married filing jointly versus individually are great enough to justify the cost of preparing the additional returns. Also, for your higher net worth clients, spousal gift exemptions apply. Prior to the federal government's recognition of same-sex marriages, if you were to give your partner more than $14,000 in any one year, you were supposed to be filing a federal gift tax return. I doubt many people did, but you were supposed to. In addition, if you went over that $14,000, it would begin to eat into your lifetime exclusion. The other benefit of the IRS recognition of marriages is that couples may file amended returns for up to 3 years prior to this year and get refunds if they are entitled to do so. The Windsor decision has also affected plans under ERISA and plans for health care. Any pension plan covered by ERISA must provide benefits to same-sex couples. If you're applying for a health plan under the ACA, you'll be treated as married. Individual employer plans, you're generally going to be looking at the principal place of business of the employer as to whether same-sex marriages will be recognized for purposes of employee benefits. One of my friends in Indiana, her husband actually works for a company headquartered here in Massachusetts, and he works remotely. And that's one of the benefits of that, is that they would recognize a same-sex marriage. And she got Massachusetts health care, which I have to tell you, you guys have some Cadillac health care here in this state. Massachusetts Blue Cross was pretty nice. Federal retirees. Federal retirement plans now recognize same-sex marriages. And the federal government has allowed current retirees to take up until the end of 2015, so 2 years from the date of the Windsor decision, to add their spouses to their pensions. So they gave them a window of 2 years to go get married and sign up their spouses for their federal benefits. Shifting away from the government benefits angle of the Windsor decision, I want to talk about the planning that needs to go into planning for a same-sex couple. As I said, people cross state lines on a daily basis. I crossed a state line just coming from the airport to here, coming in from Connecticut. And I tell my clients in South Bend, that's great that you live in Indiana and we're following Indiana's rules, but if you have a heart attack a mile north, which hospital are they going to ship you to? You're probably going to end up in a hospital in Michigan. So when you're looking at planning for powers of attorney and healthcare decision-making, healthcare decision-making can be one of the toughest planning issues for same-sex couples. Your primary question is going to be, what's the default in state of residence? I tell all my clients to absolutely never rely on the default. You don't want to rely on your state's healthcare decision-making statutes. You want to make sure you have a written healthcare power of attorney or healthcare representative in place. And that is never more true than when you're dealing with same-sex couples. Because if you happen to be injured in a state where your marriage is not recognized, if you do not have a healthcare power of attorney or a written healthcare representative in place, depending on what the term is in your state, doctors can refuse to speak to your spouse. And in some states, the healthcare decision-making statutes give equal weight to spouses and family members. Some states have statutes that say, in the absence of a written directive, the doctor may take direction from any of the following. And, this is equally true for heterosexual couples, but if mom and dad didn't approve of that marriage, and you don't have a written power of attorney in place, mom and dad can come stomping in and demand equal say in your healthcare decisions, whether you've spoken to them in the last 20 years or not. So you need to be familiar with what the defaults are in your state, and you need to counsel your clients that they need to execute written directives and written powers of attorney because you cannot control where they are when they are in a car accident. And you cannot give them any security, even for heterosexual couples, that the spouse will be given primary role in decision making. If you're in a state that just simply does not recognize the marriage, absent that power of attorney, you have no authority. So when you're planning for same-sex couples, written documents are imperative. And I can't say this enough. The problem is that if they're coming to us, they're getting the written documents. The dangers are for the folks who don't know that this is a problem. And so I encourage you, to the extent you do speaking in your communities about elder law planning, if you're not already mentioning, even if the presentation is about veterans benefits, I start off with how many people in the room have a healthcare power of attorney in place. And if you don't, you need to get one. I force it into the presentations because I really feel it's that important. If you have to go to a guardianship, there are some states in which the spouse is not automatically the presumptive guardian. There again, the written documents become critical. And if there are prior documents in place that give someone else the written authority, the spouse may be completely out of the loop. Clients need to reevaluate their designations on powers of attorney. I tell them at a minimum, if you have a major life change like getting married, but you'd be surprised how many people, I see it even in heterosexual couples who come in who are on their third marriage, and when they pull out the estate planning binder, we're still naming the first wife. Which brings me to estate planning. If people are coming to us, they recognize that they need to be doing some form of estate planning. But the estate planning that you do for same-sex couples is going to be different depending on where you practice, where your clients live, where they may retire. And you need to advise your same-sex couple estate planning clients that if you are even contemplating a move to another state, you should call an attorney in that state to discuss how your estate plan may change. Because we've all seen the clients who move to Florida or Arizona to retire and never get around to rewriting their estate plan. And so they're still using an Indiana will, even though they've lived in Florida for the last 10 years. Where that becomes a problem is the question of whether to name your spouse in the document. And I don't mean saying that I bequeath my estate to Jane Doe. I mean up in the definitions on your will or your trust, defining the term spouse to mean Jane Doe or John Doe. And there are pros and cons. The biggest pro is that if I've never met Jane and Sally, and their siblings or children come to me to probate the estate, if I've got my spouse Jane Doe right in the front of the document, I know what's going on. And I know there was a marital relationship. The con is a long discussion I had with some folks in Indiana before coming here. Because in the state of Indiana, if you name, if I were to name my spouse, J. VanderVeen, and say that I leave everything to my spouse as a defined term, and my husband and I get divorced, that bequest is void. And it is treated as if he predeceased me. So I raised the question to a number of attorneys in our state. I said, if I were to marry Sally in Massachusetts, and my will said I leave everything to my spouse, and my spouse is defined as Sally, and we probate that will here in the state of Indiana, what happens? And the first answer was we end up at the Supreme Court. But everyone was of the belief that Indiana law would void that bequest. because the marital relationship did not exist according to the laws of the state of Indiana at the time of death. There is a way around this, and that is what Cynthia Barrett calls her savings clause. And I will shamelessly admit that I pilfered this from Cynthia's materials, and now I'm using it in all of my documents. And the savings clause simply says that I intend any bequest made to Sally to survive whether the marital relationship is valid or not. Now, obviously, what you've done there is you've saved yourself if your estate is probated in a state that does not recognize the marriage. The trap you fall into is then, what if you get a divorce? Guess what? Your estate is still going to Sally. So anytime you're drafting documents, well, not anytime, until we have marriage equality in all 50 states, and we can stand here and say the results will be the same no matter where that will is probated, same-sex couples need to be more vigilant in maintaining and updating their estate planning documents, because there are too many tricks and traps that they could fall into that would result in unintended consequences. Now, you may not have Jane and Sally sitting across from you at the conference room. You may have Jane's parents. And you're doing an estate plan for Jane's parents. And Jane's parents' will may say, if Jane predeceases me, her share goes to her then living issue in equal shares per stirpes. We've all seen the language in our documents, or some variation thereof. Well, what happens if Jane and Sally's marriage is not recognized in the state where Jane's parents live and pass away, and their will is probated? Who are Jane's then living issue? Particularly if she is not the biological parent. Many states would make the case that her then living issue would be limited to her biological children because she would not be recognized as a same-sex adoptive parent in a state where same-sex marriage is not considered legal. So if Jane's parents' intent is to benefit the 3 adopted children or the 3 biological children of Jane and Sally, using your blanket language of Jane's then living issue is not going to work. You need to specifically name the children that you intend to benefit. And if they have more children, you need to amend the documents to include them, to make sure that the intent of your client is met in benefiting their grandchildren. You also need, just as an aside, you may need to change your intake questionnaires for your current clients to make certain that you are picking up on these issues. You know, my intake questionnaire for years just said child, and I want the spouse's name, and if they weren't married, or if the parents didn't consider the marriage legal, they wouldn't list the same-sex spouse. So it now says spouse/partner/significant other. And under grandchildren, I now specifically want to know if they are your child's biological children or not, so that I can make sure the planning is worded correctly to cover those kids. Estate and inheritance tax. Once again, 50 states, 50 issues. The easy one, for purposes of the federal estate tax, your spousal exemptions and portability apply. This was the crux of the Windsor decision, that for purposes of federal estate tax, you are entitled to your spousal exemption. However, 50 states, 50 issues. There are still several states which have per beneficiary inheritance taxes. Indiana's was just abolished this past year. And when you look at per beneficiary inheritance taxes, If a same-sex marriage is not recognized in that state, the spouse defaults down to what in Indiana we call the other category. Some states call it friend, typically with the lowest possible exemption and the highest possible rates. States which have estate taxes without a per beneficiary tax may not recognize a spousal exemption for a same-sex spouse, kicking you into paying estate tax when you otherwise would not have. And there really isn't a good way around them. For a lot of these taxes, the only way to avoid paying them is lifetime gifts. Well, when you're dealing with a same-sex couple who have held everything jointly for the last 30 years, do you hedge your bets and put everything in the spouse's name who's the healthiest to try to avoid the tax? And make sure you do it outside of whatever your state's clawback period is, so it doesn't get clawed back into the inheritance taxes. One device that I have used, and I used prior to Indiana's abolishment of the inheritance tax, is an irrevocable trust to hold real estate, and hopefully getting it out of both of their names to avoid paying some outrageous tax at the first spouse's death. But in a lot of states, there really isn't a good way to plan around it. I actually advised one couple to move to Michigan because Michigan didn't have a per beneficiary inheritance tax. And I said, if you don't want to pay the tax, move across the border, because that was the best available option I had for them. With retirement accounts, planning with 401ks and IRAs, you can now do spousal rollovers at the death of the first spouse for a same-sex couple. This is a huge benefit for same-sex couples. And conversely, in a divorce situation between same-sex couples, you can use a qualified domestic relations order to transfer the retirement account to the other spouse. This is a technique that I find myself using more and more often in Medicaid planning, where the spouse going into the nursing home is sitting on a large IRA or 401k that otherwise would have to be cashed in order to be transferred to the name of the community spouse. Unfortunately, more and more I'm resorting to divorce in order to transfer that account over to the community spouse. And now we have that option for same-sex couples in states where the marriage is recognized and you can actually accomplish a divorce. To marry or not to marry? That is the question. It's a very similar analysis to when you're talking to other elderly couples, who may have met in the assisted living, fallen in love, and now want to get married. And you have to do an analysis of the potential benefits and losses for any marriage. I've developed quite the reputation in my area for being an advocate of shacking up, because in a lot of situations, particularly with elderly couples, where both of them may be bringing substantial assets into the marriage, getting married simply doesn't make sense. If you've got a widow who's receiving her husband's Social Security benefit, maybe a VA pension based on her husband's service, and maybe his pension benefits from his employment, who has now fallen in love with Sally next door, and the two of them want to get married, great for them, but do you realize what you'll be losing in income on a monthly basis if that marriage goes through? Actually, in one of the assisted living facilities in my area, there is a minister who will perform ceremonial marriages without a legal license, so that the couple can have their marriage and feel okay living together without the legal license to terminate any spousal benefits they may be receiving. Then we have the issue with some of our special needs clients of, will that marriage terminate public benefits? Will they lose their insurance through Medicaid? Will they lose their waiver services? Will they lose their SSI? SSI, I'll tell my clients when they're looking at whether or not they should get married if they're disabled and receiving SSI. To me, that's not necessarily a barrier because the benefits are so low. It's usually the Medicaid benefits and potential waiver services that we're looking at. But you have to sit down and do this practical analysis with your clients who are looking at each other all moon-eyed in love when you tell them, don't get married. Half the time I've got the kids on either side of me too, agreeing with me. Which brings me to my next topic, prenuptial agreements. It's the same for same-sex couples as for heterosexual couples. I told some of my friends in Illinois who are getting ready to get married, I'm like, welcome to the world of marriage. Let's talk about your prenup. The only difference with same-sex couples is you have to address what I call portability concerns. We've gotten married in Illinois and we've moved to Indiana. Where are we going to get divorced? And if you're living in Indiana, can you come up with child custody and other agreements outside of what the state of Indiana would provide? The answer to that, in most cases, is if you're heading for the big D, you're heading back to the state where you got married. Most states which allow same-sex marriage provide for out-of-state individuals to return to the state of the marriage to get a divorce without meeting residency requirements. So if you're planning that lavish marriage ceremony in Hawaii, you may want to think practically about what you would have to do if you needed to get divorced. Because you would have to go back to Hawaii to get that divorce if the state you are living in does not recognize same-sex marriages. I'm going to grab the cord of my questions over here. All right. Why did the federal government focus on the state of celebration versus the state of residence? Not being inside their heads, I can't say for certain, but what I can say is that the state of celebration is a much cleaner way of looking at it from a federal perspective. Because the federal government, post-Windsor, has essentially been ordered to recognize same-sex marriages performed where the marriage is legal. And so I think actually the agencies that are focusing on state of celebration are more on the right side of the Windsor decision than those that are focusing on state of residence. Because I read Windsor to say that if the marriage was legal in the place where it was performed, the federal government has to recognize it. Now, I think it was more of a practical decision in that the state of celebration is easier to prove because you simply submit a marriage license, whereas proving residence requires a few more steps. But, as we've seen, some of the agencies are going with state of residence. Now, the agencies that are going with state of residence, with the exception of the VA, for example, Social Security, they're basing it on state of residence because when you apply for Social Security benefits, where do you go? You go to the Social Security office nearest your home or the Social Security office in your state. And so they're allowing those local offices to have more control over the system. The next question is, what about same-sex couples who adopt as far as Social Security and Medicare? They're in a gray zone. They're in a total gray zone right now, and the Social Security website acknowledges that they are in a gray zone. If a same-sex couple adopts a child and they are living in a state that recognizes the same-sex marriage, Social Security is clear that the benefits would be approved for that child. If a same-sex couple adopts a child and lives in a state where that marriage is not recognized, Social Security actually says on their website that application will be put on hold. They're going to shuffle it off to some box somewhere until they can decide what they're going to do with those cases. So adoptive children of same-sex couples for purposes of Social Security right now are in limbo, probably more so than anybody else, because they just really haven't been able to decide what they want to do. You know, Windsor decision is still pretty fresh, and like I said earlier, there's been no statutory response to the Windsor decision to really codify what is going on. And I think until we see a clear response, then we're going to keep having these questions and these issues. The Social Security website, when I actually looked at it 2 days ago preparing for this presentation, and it had changed since the last time I looked at it about a month ago. So it's constantly changing, and they're constantly altering their position on these issues. So until we have some real clarity, and the Windsor decision itself was not entirely clear. So for right now, you know, I'm giving a presentation that for all intents and purposes could be obsolete next week. But hopefully I've been able to give you some guidance about how to plan for same-sex couples in our wonderful post-Windsor world. Thank you.